No, Your Honor, the doctor's report has come in. And she'd been found competent, so she was found competent.
Okay,
There wasn't an evaluation, but she was found competent.
so I guess it's
An announcement.
what do you want to do?
Said she wants to sit her own trial doc, is what she said. I mean, I still don't think she's competent, but the doctor does. So can't argue that.
Edward Wilson. Who gets this? I have two cases here. 23 CR 1802 and 1803. You were Ephraim Wilson in each case. You were charged with a state jail felony of fraudulent use of identifying information on or about April 19th, 2023 in Jefferson County, Texas. And finally, third-degree felony of illegal possession of methamphetamine from 23 CR 1803. You're looking at up to 2 years in the state jail, and if convicted in 1802, and up to 10 years imprisonment in 1803. You understand what you're charged with here? Okay, what are we doing?
He wants to plead not guilty and have them both set on the trial docket, Charlie.
Is that right, sir? That's what you want? All right. All right, we'll set them on the trial docket.
And he would also like the cases disposed of as soon as possible. I've advised him of my trial schedule and my court schedule. He's asking that I be replaced with another attorney to be appointed.
Is that what you're doing? Or because under the rules that the Indigent Commission follows very closely and polices us, and we just don't just indiscriminately pass on appointments from the public defenders to the rotation lawyers. Are you able to hire a lawyer?
This is what I plan on doing.
Sir?
This is what I plan on doing, Your Honor. It's hiring time.
How are you going to do that?
As soon as I find out.
Why haven't you bonded that out yet?
Because they want me to go to court first. The bond.
Really? That's interesting.
I'm out of county.
Okay, so you can hire a lawyer.
Yes, sir. Yes, Your Honor.
All right. Well, what I'm going to do is, under these circumstances, I'm not going to flirt with trouble. Mr. Dusler is going to continue to represent you. We're going to place it on the trial docket, but I want to review this. I mean, how you have money to post a bond, huh?
Yes, Your Honor.
Why are you in jail? If you can do that.
I like it here, just like camping.
You don't, if you don't know, who knows? My God, this is your life. Is there any competency issue here?
No, sir, there's not. But
Really?
he has advised me on more than one occasion that he wants to try to hire somebody. I don't see it coming. I don't see anything.
Well, I'm just not going to
and that's
flippantly release Mr. Dusler at this stage, but we're going to set it on the trial docket. And what I want to do is review it in 3 weeks just to see if you're out or not. Okay. And see what the status is. Okay. That's what I'm going to do in this case. It's kind of a weird situation. Okay. That's what we're going to do. Beatty, Vicarian Beatty. That's a sentencing, right?
Yes, sir.
Case. You just made more of a mess here, didn't you? I think. All right. I don't know what else Jonathan Ramos?
Speak up real loud, Steve.
All right, 23 CR 1533. is called 23 CR 1534 and 23 CR 1535. Each of these cases, and you understand English?
Yes, sir.
Okay. Each of these cases are indictments which similarly allege the same victim complainant, and you on different dates in 2023, all alleging in Jefferson County, Texas, that you committed the second degree felonies in each case of indecency with the child by engaging in sexual contact with the child, person younger than 17 years of age. Do you understand what you're charged with in each of these cases?
Yes, sir.
If convicted of a second degree felony, you face no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed in each case. Do you understand?
Yes, sir.
Now, Mr. Gertz is here, who is a very fine lawyer representing you. What are we going to do today?
Judge, we filed an application for a writ of habeas corpus regarding the bond amount. Currently, the bonds on 3 cases total $225,000. We're asking the court to reduce those to $20,000 apiece, respectively, or totaling $60,000. And I would want to, for the limited purpose of discussing my client's financial situation, put my client under oath and ask him a few questions if we may.
All right, go ahead. Raise your right hand. Do you solemnly swear or affirm any statements you make today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. Go ahead.
Mr. Ramos, look, I'm going to talk a little bit about your financial situation. I need this lady to be able to hear you here too, so I'm going to try not to stand in front of you. But do you have a checking account?
Yes, sir.
Okay, what is the amount approximately?
the PC?
What amount
Yes.
approximately is in your checking account?
$3,000.
$3,000. Okay. And what about a savings account? Do you have any kind of savings account? All right. Do you have any kind of stocks or bonds or anything like that independently?
401k.
Okay. How much is in your 401k?
After tax, roughly about 5,000.
Okay. And when you say after taxes, what we're talking about is it'd be a penalty if you took them out.
I took out 11,700.
It's 11,700. Okay. So that those funds are not readily available to you. Is that fair to say? Okay. Do you own any unencumbered property? And by that, I mean property that doesn't have a lien on it that you could immediately borrow on or sell or something of that nature. Okay. So you have one vehicle.
One vehicle and my business trailer and
Okay.
lawnmower.
Okay. Are those things unencumbered?
Yes.
But if you were to sell those things, you wouldn't have transportation or be able to work. Is that fair?
Yes.
Okay. All right. Do you have any other source of funds of your own that you could access or use to make bond at this point, especially while you're in custody?
Yes.
Judge, that's all the question I have for him about his finances.
Any questions from the staff?
Okay. I don't have anything further.
The court is guided by the rules of law in assessing, making a formed decision in how much bond and what the circumstances are of the rules of fixing an amount of bond or appropriate in each case. And a bond is important because bond is an issue that is set forth in the rules as it's inherent with the blessed right of presumption of innocence. The court's very intimately familiar with that. I've written an article on that, done a lot of research and spoken to legal presentations, and I believe that was very the essence of a right that is founded in the Constitution and has been rooted in the Old Testament. So it's blessed. Now, the nature of the offense and the circumstances under which it was committed are to be considered. The future safety of a victim of the alleged offense is to be considered. That's one of the 5 principles in the 5 sections under Article 17.1415 of the Texas Code of Criminal Procedure, setting forth the rules for fixing the amount of bond. Court decisions have also spoken about other issues as well that are important for considerations if brought up, that should be considered. I'm looking at the probable cause affidavit. Each of these cases, the indictments similarly allege allegations of events involving a child, alleged the same child. So on 3 occasions, it is inferred from the indictment, at least 3 occasions, at least the 3 indicted occasions, that the defendant made contact with the sexual organ of a child. It also states that in the probable cause that intentionally and knowingly during a period of 30 or more days committed 2 or more acts of sexual abuse against a child under 14 years of age, which is not indecency, is it? I mean, isn't that a different crime?
It is, Judge, but that's not.
That's continuous sexual
Yeah,
assault of a
they
child.
initially-
That was not indicted, though.
They initially submitted it as a continuous, Judge. And if I may, Your Honor, I do want the court informed that he has a prior conviction, not for this type of offense, but it does impact his ability to be.
Right.
not
I don't know
eligible for
anything about that. Can you
probation.
enlighten me about it?
Yes, Your Honor. It is a burger of a building that dates back to 2010. He was given an opportunity at probation, which was revoked. He was sentenced to 365
Whose court
days.
was that in?
That was in the 25th District Court, Gonzales County, Texas.
Okay.
At the time we filed this, Judge, we had not received discovery. I'm not sure.
That's okay.
We had that, so I'm.
That's okay. Are you challenging that?
I don't have.
You don't know anything
I didn't know
about it?
anything about it. That's all I would say. And I'm just fussing with Mr.
Which would
Hammond,
mean
I'm just saying.
that the defendant would not be eligible for probation
I'm sure from a jury.
from jury.
It is a factor I'd like for you to consider in setting bond, Judge.
Do you have any circumstances about that? Any details on that?
About the offense?
That previous offense?
Nothing that would indicate that it's of a sexual nature, Judge. Since that's what this offense is.
All right. About this case, anything you would like to add of information for the court on this case?
Your Honor, I would like for you to I know you've gotten the probable cause. You'll note that the child is 10 years old. I would ask that you consider that. The fact that it's a repetitive accusation, even though we didn't accuse it as a continuous, there are 3 separate accusations here. And I would ask that you consider that and factoring in with the.
What are you asking the court to do?
I believe that the amount that is set is proper.
All right, go ahead, defense. Anything else you want to add?
No, Judge, just that we, obviously all 5 of the factors are important. He's a lifelong resident of Texas, and we've obviously put on testimony about his ability to make bond. He's not a flight risk. He's, there's no evidence to support the notion that he is, and so we're asking the court to reduce the bonds to $20,000 a piece, which is still a significant amount of money, especially given his financial situation of having basically access to a total of $8,000 in a used car. And so.
Okay. All right, the nature of the offense and the circumstances in which you're committed are to be considered. And no one can possibly say that the allegations here are not disturbing. Okay. They are. A child, 10 years of age. What is the price of innocence lost at 10 years of age? A child's first sexual involvement of sex should be on certainly their terms, not by someone else's, an adult. The relationship, I'm a little unclear. The relationship of the complainant to the defendant is what?
He's her stepfather.
Not natural father, but stepfather.
Correct.
And these involve 3 different events which carry with it their own punishment range for their own event.
Yes, sir.
All of us would have to agree that allegations of indecency with a child under these circumstances are most serious. And a child in a home is going to be unable to really effectively defend themselves when a parental figure is alleged to have been causing the harm. And so it's just, it's really unnatural that behavior like that should occur. So it is going to have to be considered an aggravated feature. The future safety of a victim in the alleged offense and the community to be considered. Anybody want to add anything about that?
Judge, I would just say he would obviously follow any terms and conditions that the court sets that I think would be the same regardless of whether the bond is 225 or 60,000.
Okay, just 1 second. What do you know about the prior conviction?
I know that he was given a chance at probation.
Was he?
Yes, sir.
Okay.
And that he had standard rules and conditions similar to what counsel was just arguing, and he failed.
What about that?
Again, Judge, I've just had a cursory view of this.
I know
here's my answer.
Do you challenge that, or you're just unable to right now?
I'm unable to, but here's my response to it. Generally, would always be the same, and it's this: what we're talking about is just a financial penalty. And that's what bond in this kind of situation is. And it's $60,000 is a significant amount of money to have as a bond.
What we're talking about are rules and conditions set forth by a judge.
No question.
And they are no less important than conditions of probation, if more so, because conditions of probation, failure to properly follow the conditions of probation can result in conviction. This does not. This does not. A bond failure or a bond condition issue does not result in a conviction, but it does have something to do with liberty, and that is important.
But in this kind of case, though, Judge, again, the court would set the same types of bond conditions regardless of what the bond amount is. What we're asking for is for the bond amount to be lower. We're not asking for any special consideration different than what the court would normally do. So then at that point, once we assume those two things are equivalent to each other, then all we're talking about is a financial penalty. And as the court said, and it's true, these are just allegations. I mean, my client is presumed innocent, and At this point, these are just allegations. We don't know anything about the facts of those allegations, other than what's in a probable cause affidavit. So,
But Article 17.15,
I agree.
it infers the legislature understood presumption of innocence and beyond a reasonable doubt standard. And they put what they put in there to be considered that would affect somebody's liberty. So I'm going to follow that. Yeah.
If I may, Judge, from the pin packet in regards to that offense, I would highlight number 2 and the fact that he failed to report on too many occasions to count. And that's the basics for the requirements of any bond condition is reporting for court assessed times. The state stands by the fact that the bonds and where they're set is appropriate considering the offense. And when you factor in his prior conduct, Judge, safety of the victim demands that it stays where it's at. I got you. Got it now.
State has tendered to court proceedings under case number 62 -00-CR out of the 25th District Court of Gonzales County involving the defendant Jonathan Lee Ramos, who the state states and asserts is the same as the person is this defendant. The defendant was placed on probation according to these documents on it doesn't make sense. All right, there's more to this than just meets the eye on this one. In this, because I'm looking at about 25 pages of documents in court judgments. You hadn't seen any of this?
I mean, just the, Mr.
Okay.
Hyden gave me a few of them this morning, just a moment.
Okay. Apparently the defendant was placed on deferred or unadjudicated probation. On August 14th, 2000 for the offense of burglary of a building. He was placed on 5 years deferred or unadjudicated probation. And his probation was revoked for failing to avoid injurious or vicious habits, but not limited to the use of controlled substances, using marijuana while on probation, failing to report as directed, and that he's failed to report on or about August 27th, October 17th, 2001, May 16th, 2002, May 14th, August 25th, October 25th, October 6th, October 18th, November 4th, November 19th, December 20th, 2004. The defendant also violated the condition by failing to pay supervisory fees, violated the provision of probation by failing to pay for urine screening, and violated probation by failing to attend and participate in GED program. Because of those 5 reasons, his deferred or unadjudicated probation was revoked. He was found guilty and sentenced to 2 years in the state jail, and that was adjudicated, and his confinement was suspended, and he was placed on regular probation for 5 years. And this says the date of judgment is 2006. Didn't end there. His regular probation was later revoked as he pleaded true to ten or it was deemed by the court that he violated 10 conditions of his probation, committing an offense by committing the offense of displaying an altered license plate, violating his probation by testing positive for marijuana, violated his probation by failing to report to the Williamson County Probation Office on June 1st of 2009 and May 29th of 2009, violated his 9th condition of probation by failing to obtain employment, violated his probation by failing to pay for urinalysis fee, failing to violate his probation by failing to make payments on his fees, supervisory fees, violated his probation by failing to pay other types of fees on his probation, violated his probation by failing to complete his drug offender education program, violated his probation. By failing to report to the Gonzales County Jail on May 29th, 2009, where he was ordered as a condition of his probation to serve 15 days in the county jail. And finally, violated his probation, the 65th conviction, the 65th condition of probation. By apparently they have as much as 65 conditions. Failing to cooperate, participate, and successfully complete substance abuse cognitive class. His probation, his regular probation was then revoked, and he was sentenced to 365 days state jail at the end of all of that in 2000 on March 24th of 2010. So that was a decade long of supervision, which resulted in placement on deferred, revocation of deferred, placement on regular probation, failure, and sentence of confinement in prison. So the court made affirmative findings in this regard that he, correct me if I'm wrong, but failed 16 separate violations of probation throughout the courses of the deferred, and so not the least of which was failing to show up when he was supposed to for jail and for probation. So this court, in looking at this, and get a record, please get a copy to Mr. Gertz as soon as possible.
I have during this hearing.
This court is convinced that his conduct while under supervision in the Gonzales County, in that case, woefully showed that he really doesn't appreciate nor respect nor is willing to follow terms and conditions of probation. And the court thus feels that the bonds are correct in what they are due to his history of failing to follow conditions of probation. And with these more serious crimes now alleged, and looking at the circumstances of this case, along with his history of probation, where he was placed on deferred, revoked, placed on regular probation, then revoked, 16 violations, which included failing to appear for jail sentence, failing to appear to probation. This court shows he's proven that he is not worthy of being trusted on conditions of bond. So the application is denied.
Thanks, Judge.
Thank you. All right.
Adiós.